Imagine this. You've worked your entire life to build a legacy, a home filled with memories, savings for your children's education, cherished heirlooms passed down through generations. Now, picture the state dismantling that legacy, distributing it to distant relatives you barely know, or even claiming it outright. This isn't dystopian fiction. It's the reality for thousands who die intestate without a valid will. In this comprehensive guide, we'll dissect every layer of intestate succession, the rigid legal hierarchies that override your unwritten wishes, the shocking variations between state laws, and the heartbreaking family conflicts that erupt when courts intervene. Through real case studies, expert interviews, and plain English legal breakdowns, you'll discover why "I don't have enough assets for a will" is a dangerous myth and how to shield you, our loved ones, from bureaucratic chaos. Phrase form visual presentation. Intestate equals government control. No will, your state's laws dictate inheritance. The ripple effect: probate delays 1 to 4 months, forced property sales. Estranged heirs. Myth versus reality: my spouse gets everything automatically, gives rarely true. Urgency check: 68% of Americans lack wills. Don't be part of this statistic. Chapter 1: Intestate Succession Decoded. 25 minutes. Paragraph form: dying intestate triggers a default inheritor. This protocol written into your state's probate coda, one-size-fits-all formula, ignoring personal relationships. We'll unpack the mechanics. First, the probate court appoints an administrator, often a stranger, not your trusted friend, to inventory your probate assets, everything solely in your name. From real estate to vintage record collections. Crucially, non-probate assets like life insurance or jointly owned property bypass this system. Next, the court applies your state's intestacy statute of flowchart, prioritizing legal heirs, spouses, blood relatives, while excluding unmarried partners, stepchildren, or charities. The process is end-free. Attorney fees, court costs, and executor commissions can devour 3 to 7% of your state's value. Worse, minor heirs face court-supervised guardianships until adulthood, depleting their inheritance through restricted withdrawals and annual accountings. Phrase form: key players. Decedent: the deceased person. Administrator: court-appointed estate manager, not your choice. Probate assets: solely owned property subject to distribution. The hidden tax: $10,000 estate gives $300, $700 lost to fees. Children's burden: minors inherit via custodial accounts. UGMA, no direct access until 18-1. Excluded parties: unmarried partners, close friends, charities, pets. Chapter 2: The Inheritance Hierarchy, Who Trumps Whom. 30 minutes. Paragraph form: states enforce a rigid caste system for heirs. Your surviving spouse sits atop the pyramid, but with caveats. In common law states, e.g., Illinois, if you have children together, your spouse might receive only 33 to 50% of the estate. The balance splits equally among children. If those children are from a prior relationship, your spouse could inherit just the elective share, often 25 to 33%, while your children claim the remainder. No spouse or children, assets flow downward, first to parents, if deceased, to siblings, if none, to nieces, nephews, finally, to distant cousins with the state. But biology and destiny: an estranged child who never spoke to you inherits equally with devoted children. A half-sibling typically shares fully unless state law specifies otherwise, e.g., Kentucky's half-blood rule. Meanwhile, a lifelong partner receives nothing even if they shared your home for decades. Phrase form: common Law state breakdown, e.g., New York, spouse plus children gives spouse $50,000 plus 50% of residue. Children, 50% split equally. Spouse alone gives 100% only if no parents, siblings survive. Children alone gives equal shares. Biological, adopted, estrangement paradox. Hostile children inherit identically to lovi. Ones. Half-sibling complexity, full rights in 40 states, limited rights in others. The partner penalty. Unmarried couples equals $0 inheritance without legal safeguards. Chapter 3. State law showdown. Why location dictates legacy. 35 minutes. Paragraph form. Your zip code could radically alter your family's inheritance. Consider community property states: Arizona, California, Texas, etc. Assets acquired during marriage are owned 50/50ths. Thus, a surviving spouse keeps their half outright, but the decedents have follows intestate rules. Result: if you die childless, your spouse retains 100%. With children, they keep 50% while your children split your 50%. Contrast this with common law states. All assets are individually owned. So a $1 million estate with one child might give the spouse $500,000 and the child $500,000. Worse, multi-state property. A vacation home in Florida common law and a primary residence in California community property could fracture distribution requiring dual probate proceedings. We'll analyze shocking discrepancies. A $750,000 estate in Idaho leaves a spouse with 100%. In Pennsylvania, that same estate forces a 50/50th split with adult children. Phrase form. Community property. 9 states. Spouses half, automatically retained. Decedents half, distributed via intestacy. Common law. 41 states. Fixed percentages override ownership history. Elective share loopholes. Spouses in common law states can claim 25 to 50% if disinherited. Multi-state probate. Double fees. Conflicting rulings. Years-long delays. Chapter 4. Blended families and unconventional relationships. The perfect storm. 25 minutes. Paragraph form. Modern families face brutal intestacy outcomes in a blended household. Your surviving spouse could inherit your shared home while your children from a prior marriage demanded sale to claim their share. Stepchildren. Without legal adoption, they're excluded entirely. Unmarried partners face eviction. Without rights to the home, they're at the mercy of blood heirs. Consider Maria's story. After 22 years with James, his death without a will transferred their home to his estranged sister, leaving Maria homeless. LGBTQ+ couples face added peril. In states without robust common law marriage recognition, partners risk total disinheritance. Even foster children raised as your own typically inherit nothing without formal adoption. The solution: cohabitation agreements, revocable living trusts, or strategic joint ownership with rights of survivorship. Phrase form. Blended family pitfalls. Spouse inherits house, gives children, demand for sale. Stepchildren. 0 rights without adoption paperwork. Domestic partners. 37 states offer no protection. Gives heirs can evict within weeks. Case study. Estate of Blanchflower, New Hampshire. 2004. Unmarried partner lost $400,000 estate to deceased siblings. Safety nets. Transfer on death deeds. Life estate deeds. Beneficiary designations. Chapter 5. Real estate, the number one asset at risk. 20 minutes. Paragraph form. Your home epitomizes intestacy chaos. If jointly owned, e.g. JTWROS, joint tenancy with right of survivorship, it passes directly to the co-owner. But if solely owned, It enters probate where heirs rarely keep it. Why? Mortgages don't vanish. Inheritors must qualify to refinance or sell. Minor children complicate this. Courts appoint conservators who often sell to avoid liability. Even paid-off homes face threats. Siblings inheriting equal shares may force a sale. Capital gains taxes erode proceeds, or distant heirs demand partition lawsuits. Will tour alternatives. Transfer on death deeds available in 36 states bypass probate. Lady Bird deeds Florida. Texas lets spouses retain lifetime use, or placing property in a trust avoids court entirely. Phrase form. So loan home. Probate gives, sale gives, heirs split cash not property. The refinance trap. Heirs need 650 plus credit scores to assume mortgages. Minor heirs. Courts prefer liquidation gives proceeds held in restrictive accounts. Escape. Roots. Transfer on death. Deed. Filed before death gives director transfer. Life estate. Spouse lives there until death gives then passes to children. Chapter 6. Debts, taxes, and probate nightmares 25 minutes paragraph form. Before heirs see a dime, creditors descend. Funeral costs. Medical bills. Credit card debt. Even unresolved lawsuits are paid first from estate funds. Federal estate taxes rarely apply threshold. $13.61 million in 2024. But 17 states levy inheritance taxes with rates up to 18%, e.g. Pennsylvania. Worse? Probate's timeline: 9 months minimum in simple cases, 3 years with disputes. During this freeze, assets can't be sold or accessed. Families drain savings to cover living expenses. Will expose fee structures. Attorneys charge hourly $250, $500, or a percentage 3 to 5% of estate value. Administrators collect commissions. Courts impose filing fees. Result: a $300,000 estate could lose $15,000, $25,000 before distribution. And if debts exceed assets, heirs inherit nothing and aren't liable for the shortfall. Phrase form: creditor hierarchy. Funeral expense, secured debts, mortgages, taxes, unsecured debts, credit cards. State. Inheritance taxes. Pennsylvania 4.5%. Spouse. Children gives 15%, siblings gives 18%, others. Kentucky. Exempt spouses gives charges children for to 16%. Probate costs. $2,000 minimal estate gives. $50,000 plus complex estates. Chapter 7. Real-life case studies. When intestacy unravels lives 25 minutes paragraph form narration. These harrowing true stories expose the human cost of intestacy. First, Robert, a Florida man who cohabited with his partner Elena for 18 years. When he died suddenly without a will, state law bypassed Elena entirely. His estate, including the home she helped maintain, passed to a third cousin he'd never met. Elena faced eviction within 90 days. Estate of Smith, 2019. Second, the Chen siblings. Their parents died intestate in Ohio, leaving a $750,000 home equally to all 3 children. When sister Mei-Ling, who lived in the home, refused to sell, her brother sued for partition. 2 years of probate battles ensued, culminating in a forced sale at 20% below market value. Legal fees consumed $58,000 in Ray Chen, 2021. Third, a veteran's $300,000 life savings escheated to California after DNA testing failed to locate heirs despite a local church having records of his intended charitable bequest. These cases underscore how intestacy weaponizes bureaucracy against grieving families. Phrase form visual presentation. Case 1. The invisible partner sets. Home. Retirement accounts gives value. $for 2 care. Third cousin last contact. 1987 outcome. Partner homeless. Cousins sold assets tax-free. Case 2. Sibling standoff conflict. One sibling occupies home, gives others demand sell. Illegal trigger. Partition action. Ohio Rev. Code Section 5307. 1 losses. 22% asset depletion via fees plus discounted sell. Case 3. Charity denied. Yet. Threshold. California claims assets after 3-year air search preventable with $150. Holographic will pattern. Intestacy equals family trauma plus financial hemorrhage. Active. Avoiding intestacy. Beyond basic wills. 25 minutes. Paragraph form. A sample will is your first defense, but not your only tool. For estates under $100,000, transfer on death. Todd deeds. For real estate valid in 36 states allow direct beneficiary inheritance without probate. High conflict families benefit from revocable living trusts. They avoid court entirely. Allow staggered distributions, e.g., child receives 1/3 at 25, 30, 35, and include incapacity provisions. Critically, update beneficiary forms, annually retirement accounts, and life insurance. Bypass wills entirely. After divorcing, revoke ex-spouse's inheritance rights immediately. 42 states don't auto-revoke. For digital assets, crypto, and NFTs, use a digital asset directive specifying access protocols. Finally, lentils. A pour-over will catches assets accidentally left outside trusts. Remember, estate plans expire. Review every 3 years or after major life events, births, deaths, or moves to community property states. Phrase form. Hierarchy of solutions. Beneficiary designations. IRAs for 101Ks. Pot accounts. Deeds. TOD real estate. Lady Bird Life Estate Trusts. Revocable. Avoid probate. Testamentary minor protection. Will. Catcher's net for residual assets. Divorce. Danger. 30% of ex-spouses unintentionally inherit via outdated forms. Digital safeguards. Crypto. Seed phrase and fireproof vault plus instruction. Social media. Facebook legacy contact. Google inactive manager maintenance protocol. Re-sign documents after moving to AZ, CA, ID, LA, NB, NM, TX, WA. Wake after 9. Debunking intestacy myths. Legal realities vs. folklore. 15 minutes. Paragraph form. Let's demolish dangerous misconceptions. Myth 1. The state confiscates everything. Truth. Estranged occurs only after exhaustive air searches 3-5 years in most states, and applies only if no relatives exist within 8 to 12 degrees of kinship. Second cousins twice removed. Myth 2. My spouse inherits automatically. Reality. In 41 common law states, spouses share estates with children. In Pennsylvania, a spouse with 2 children gets just 1/3. Myth 3. Small estates don't need planning. Consequences. A $40,000 bank account could fund 18 months of probate, leaving heirs $0 after debts. My. Th4. Common law marriage protects partners. Only 8 states recognize it and require proof of public cohabitation plus mutual intent. Myth 5. Handwritten notes count as wills. Just 26 states accept holographic wills and require 100% handwritten text with dated signatures. Phrase form. Myth versus fact. State takes all, gives false. Heirs found in 99.7% of cases. Spouse gets 100%, gives false, except in community property states. If no children join accounts, avoid probate. Gives partially true, only if titled JTWROS small. Estate trap. $15,000 credit card debt plus $20,000 estate equals heirs owe $0, but inherit $0. Common law marriage. Valid in CO, EX, Mount, Okay, SC. TX requires signed affidavit. The logric will validity. Requires no witnesses, but must be 100% handwritten to Tedsenden in decedent's possession. Chapter 10. Urgent finale. Your legacy is now. 10 minutes. Paragraph form. This isn't abstract law. It's the difference between leaving love or chaos. When you die intestate, you force loved ones into a labyrinth of court dates, creditor negotiations, and familial warfare. Your disabled sibling might lose Medicaid eligibility after inheriting $10,000. Your lifelong partner could be evicted by relatives you despised. Your children's inheritance might fund years of legal battles instead of college tuition. Today, draft able using free templates from AARP or legal aid clinics. Within 30 days, consult an estate attorney. Many offer $50 flat fee reviews. Finally, document your wishes in writing. Who raises your children? Who inherits grandma's ring? Which charities matter? Silence isn't neutrality, it's surrendering your voice to the state. Protect your story. Control your legacy. Phrase form. Consequences of inaction. Children's guardian equals court-appointed stranger. Family heirlooms equals sold at estate sales. Final wishes equals ignored by statute. 3 steps start today. Download state-specific will template. Find LAWELP org. Film letter of intent explaining distributions. Legally persuasive. Email documents to trusted contact. Spinal truth. Intestacy is the most expensive estate plan and the only one written by politicians.